Mr. Rosenkranz.
Thank you, Mr. Chief Justice, and may it please the Court. The Fourth Circuit held that a provider of basic communications infrastructure to millions of homes and businesses can be held liable because it did not kick enough accused infringers off the Internet. No notion of tort or copyright law ever conceived can support that theory. This Court explicitly rejected the theory in Twitter, where it said, quote, plaintiffs have identified no duty that would require communication providing services to terminate customers after discovering that the customers were using the service for illegal ends. This Court said in Grokster that liability cannot be predicated on, quote, mere failure to take affirmative steps to prevent infringement. Reaffirming those basic principles resolves this case. No case has suggested that knowledge alone can create the necessary culpability to find someone liable for infringement. The consequences of plaintiff's position are cataclysmic. There is no surefire way for an ISP to avoid liability, and the only way it can is to cut off the Internet, not just for the accused infringer, but for anyone else who happens to use the same connection. That could be entire towns, universities, or hospitals. Turning Internet providers into Internet police for all torts perpetrated on the Internet will wreak havoc with the essential medium through which modern public engages in commerce and speech. This Court should reverse. I welcome the Court's questions.
How far do you go with Twitter? We were dealing with a totally different matter in Twitter than we have here.
Well, Your Honor, the question of how far one goes with Twitter, when you think about the different—
In a sense, how does it apply here?
Oh, so Twitter's held several things that are fully applicable here. The first is that contributory liability requires malfeasance with the purpose of fostering the bad act, that there's no liability for passive nonfeasance, and there's no liability for sales to the general public on the same terms regardless of any eventual use. Twitter is, we are an a fortiori case of Twitter. Twitter at least had those communications on its own server. They were visible to Twitter. What our customers do is invisible to us in real time. Now, knowing that a particular account will infringe does not make us an accomplice, which is what's required for contributory liability. Continuing to supply the Internet is just not the same as joining with the tortfeasor in, quote, mind and hand in the infringement as in something that the ISP wants to bring about.
What is the basis of this contributory liability?
Your Honor, the basis of contributory liability for copyright, as this Court recognized in Sony, is just sort of adopting the common law in a world in which the Copyright Act itself does not prescribe secondary.
So do we do that in a broad adoption of common law, it says we had in Halberstrom? Or is it narrower than that?
Well, Your Honor, it must be, I would say, the narrowest version of common law that is available precisely because Congress did not speak directly to it. And so I would say Halberstam merely articulates a way of getting at the ultimate principles that the Copyright Act, that contributory liability is directed at, but Twitter and Smith & Wesson apply it to the exact sorts of circumstances here, which is where you've got an arm's length seller selling to millions and millions of people.
I guess I wonder, Mr.